This is a lecture for my professional responsibility class. We're continuing with our discussion of Model Rule 8.4, but here we're going to be talking about a very recent formal ethics opinion from the American Bar Association, Formal Opinion 493, which it describes the purpose, scope, and application of Model Rule 8.4G. And just as a quick reminder, Section G was added in 2016. I think on your MPRE, you're pretty likely at this point to have a question or two about Model Rule 8.4G, and you may even have some questions from this ethics opinion. And even if you don't, I really urge my students to read this particular ethics opinion very carefully because it explains this rule, which has generated a fair amount of academic controversy, and it surveys some recent disciplinary actions around the country and cases and things like that that are very interesting and will kind of get you up to speed on this important area. This model, I'm going to have two videos about this particular formal ethics opinion. The second one is going to be about the hypothetical scenarios that it gives that I think are likely to be turned into test questions at some point. Okay, so here we go. And we're just going to hit the highlights of this ethics opinion for you in case you don't have time to read through it yourself. 8.4G prohibits a lawyer from engaging in conduct related to the practice of law that the lawyer knows or reasonably should know is harassment or discrimination based on various categories, including race, sex, religion, national origin, and sexual orientation. Now, whether conduct violates the rule must be assessed using a standard of objective reasonableness. So this is not a subjective test. We're not just looking at whether another person was offended. So you won't be disciplined just because another person was offended by something you said or did. It's going to be an objective test of reasonableness, and only for conduct that is found harmful. It will have to be harmful conduct to be grounds for discipline. Now, Formal Opinion 493 says that Rule 8.4G covers conduct related to the practice of law that occurs outside the representation of a client or beyond the confines of a courtroom. In addition, it is not restricted to conduct that is severe or pervasive, a standard utilized in the employment context. And this is very important for my students to understand and keep in mind that we have a large body of employment discrimination law and sexual harassment law, workplace discrimination law. And that requires like patterns of conduct and pervasiveness in the workplace and so forth in order to rise to the level to create a cognizable claim. We're going to have a lower threshold or a higher standard imposed on lawyers here. Also keep in mind, this is not just about you and the client or what happens in the courtroom, but pertains to how you treat coworkers at your firm, how you treat your subordinates, how you treat people at bar association events and networking events and so forth. So even so, conduct that violates paragraph G will often be intentional and typically targeted at a particular individual or group of individuals, such as directing a racist or sexist epithet towards others or engaging in unwelcome, non-consensual, or physical conduct of a sexual nature. And by the way, that describes most of the disciplinary actions I've seen from the last several years related to 8.4G. It's almost always intentional conduct that's communicated directly to the victim or the target, and it's racist epithets or sexist epithets directed at the opposing party or opposing counsel or a judge that the lawyer gets angry with or something like that, or a disgruntled client that is having a falling out with the lawyer. Or we have cases where lawyers keep making unwelcome sexual advances and romantic overtures to a coworker or subordinate or person on the jury or something like that. We also have cases about judges doing this to their court staff or to jurors. Now, what does the rule not do? The rule does not prevent a lawyer from freely expressing opinions and ideas on matters of public concern, nor does it limit a lawyer's speech or conduct in settings unrelated to the practice of law. The fact that others may personally disagree with or be offended by a lawyer's expression does not establish a violation. The model rules are rules of reason, and whether conduct violates 8.4G must necessarily be judged in context from an objectively reasonable perspective. I'm going to give an example. I'm making this video in the fall of 2020. This opinion, by the way, was new in July of 2020. In the last few months, we've had nationwide protests, Black Lives Matter protests in response to police killings of unarmed people of color and mistreatment of individuals and so forth. And there's a kind of a rate, as I'm recording this, there's public debate about reforming or funding or defunding of police departments, of removing Confederate monuments and renaming streets and parks and sections of town and so forth. And there are people on both sides of these things, and they're basically talking about things like that. So if you have an opinion that monuments don't need to be removed and buildings don't need to be renamed and so forth, you can express that. We're not talking about that. That's something where there's a lively public debate about. On the other hand, you can advocate for the removal of Confederate monuments or the banning of Confederate flags and so forth. That's a valid opinion that you are free to express. Now, besides being advocates and counselors, lawyers also serve a broader public role. And this is important for my students to understand. And if you don't get anything else out of this video, I hope that you internalize this, because this is an important part of legal ethics, to understand that legal ethics is not just about you and your client or you and the state bar, but you are part of a larger legal system that affects everyone in our country and affects their life and affects their access to justice. And so we have a broad public role as officers of the court, as members of the legal profession. So, and they give a quote, and I've dropped the citation from the slide: lawyers should further the public's understanding of and confidence in the rule of law and the justice system, because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. In other words, our society, our political system depends on a reliable legal system, and you, as a future lawyer, you're going to be part of that. And so if you're doing things that undermine public confidence in the legal system or the reliability of our legal system, it has far-reaching consequences, even though you're only a small part of it. And conversely, if lawyers will understand that the things that they say and do affect everyone else and affect the whole legal system, then it's better for everyone, and it upholds our ideals of fairness and justice in our democracy. Discriminatory and harassing conduct, when engaged in by lawyers in connection with the practice of law, engenders skepticism and distrust of those charged with ensuring justice and fairness. Enforcement of Rule 8.4G is therefore critical to maintaining the public's confidence in the impartiality of the legal system and its trust in the legal profession as a whole. And so what we're doing here in the ethics opinion is trying to defend the policy rationale for having this rule. This rule 8.4G did generate quite a bit of controversy, academic controversy. Some professors have spoken out against it. Some big nonprofits and national organizations of lawyers were really opposed to it and so forth, saying that it affects free speech and so forth. And the ABA is trying to clarify what they're trying to do and why they're trying to do it. Let's go back to our slides. 8.4G prohibits conduct that is not covered by other laws, such as federal prescriptions on discrimination and harassment in the workplace. Although conduct that violates Title VII of the Civil Rights Act of 1964 would necessarily violate paragraph G, the reverse may not be true. And please note this for my students. If you are engaging in conduct that's severe enough to to violate civil rights of another person under Title VII, that will, here they're saying, and this was not clear, by the way, in the rule or the comments, but this opinion is saying that that will actually necessarily violate G. But the converse is not true. In other words, we're going to hold you to a higher standard, and the fact that you might not be found liable under Title VII does not mean that the bar is not allowed to discipline you. The bar may still discipline you for what you did. Let's keep going. Here's the example. A single instance of a lawyer making derogatory sexual comment directed towards another individual in connection with the practice of law would likely not be severe enough or pervasive enough to violate Title VII, but it would violate Rule 8.4G. The isolated nature of the conduct, however, would be a mitigating factor in the disciplinary process. So please keep in mind, could you be subject to discipline and have to go to a hearing because of a single comment or single action that you did? And the answer is yes, right? It does not have to be a pattern, does not have to be pervasive. One joke, one touching of a coworker that that's inappropriate or something like that could make you subject to discipline. Now, the state bar, of course, may have some mercy on you because this wasn't the first time offense, or it's not a repeated pattern of conduct. But even though you wouldn't be subject to legal sanctions in the courts under Title VII, the state bar is free to discipline you over a single incident, even an isolated incident. Okay, what about the constitutionality of this? And some academics have published even papers saying 8.4G is unconstitutional, it violates free speech. Well, according to the ABA, the courts have consistently upheld professional conduct rules similar to 8.4G against a First Amendment challenge. And that is actually true. And if you read the opinion, they give lots of examples. For example, in addressing the constitutional authority of a court of appeals to discipline a lawyer for conduct unbecoming a member of the bar of the court, the U.S. Supreme Court observed that a lawyer's court-granted license, quote, requires members of the bar to conduct themselves in a manner compatible with the role of courts in the administration of justice. So the U.S. Supreme Court so far is on the ABA's side with this. 8.4D's prohibition, that's an earlier section of 8.4D, 8.4, that conduct prejudicial to the administration of justice has likewise withstood constitutional challenges based on vagueness and overbreadth. So if someone's saying this is unconstitutionally vague or overly broad, that also has been hashed out by the courts, and they have sided with the ABA. The language of a rule setting guidelines for members of the bar need not meet the precise standards of clarity that might be required of rules of conduct for laymen. In other words, the courts have taken the position that we can have a heightened standard and heightened expectations for lawyers and hold you to a higher standard than we would hold the general population. Or conversely, if you are going to receive a law license and all the privileges and prestige and earning capacity and opportunities that go along with being a licensed member of the bar, you are trading some of your rights about what you're going to say and do. We have standards, and expectations about how you're going to behave and how you're going to treat people. That concludes our first video about this particular ABA ethics opinion. And I have another one that's short that just goes through the hypotheticals that I think are going to show up sooner or later as exam questions.